These are some frequently asked questions regarding state and federal judicial branches. Where is the federal court system created? The federal courts are established in Article 3 of the United States Constitution. Where's the state court system created? Our state courts are established in Article 6 of the California Constitution. What's the first provision of Article 3 of the federal Constitution? Section 1 vests the judicial power of the country in the Supreme Court and the inferior courts, we also call them the lower courts, that Congress will establish and has established. Article 3, Section 1 also specifies that there are no term limits for federal judges, and that section establishes the Chief Justice, but not the size of the Supreme Court or other specified positions in the federal court system. How many courts are there in the federal system? Congress has used its power to establish 13 courts of appeals, 94 U.S. district courts, the U.S. Court of Claims, and the U.S. Court of International Trade, as well as the U.S. bankruptcy courts. What's the second provision of Article 3 of the federal Constitution? Section 2 sets forth the powers of the federal courts, and the judiciary must consider only actual cases or controversies, which is why the federal courts utilize issues such as standing, mootness, and ripeness to limit their jurisdiction over cases. What are limits on federal court jurisdiction? Federal court jurisdiction is limited to cases that arise from the federal Constitution, federal statutes, treaties, those involving multiple states or foreign governments, and some other specified areas. What's the federal high court's jurisdiction? The Supreme Court has original jurisdiction with ambassadors or when the states are a party to a case. Are juries required in certain cases? Juries must be used for federal criminal prosecutions. What's the third provision of Article 3 of the federal Constitution? Section 3 defines treason and specifies that Congress punishes it. There are also specific requirements for cases of treason and how it can be punished. Where are state court systems authorized? All state constitutions create their respective state court systems. They all have a high court, and many states have an intermediate appellate court. All of them also have trial courts, some of which are called circuit or district courts. And most of the states also provide for courts that handle specific legal matters, such as probate or family courts. Where is California's judicial branch authorized? Article 6 of the state constitution, and it contains 23 sections, although it numbers through 22. Section 1 vests the judicial power of the state in the Supreme Court, the courts of appeal, and the superior courts. How many courts are there in this state? Section 2 specifies that there are 7 Supreme Court justices. Section 3 requires the legislature to divide the state into districts, with each of them having a court of appeal. There are 6 in the state. Section 3 requires each of the 58 counties of the state to have a superior court of 1 or more judges. And the legislature prescribes the number of judges and provides for the officers and employees of each superior court. What are the judicial branch support entities at the state level? Section 6 creates the Judicial Council, which also appoints an administrative director of the courts. Section 7 creates the Commission on Judicial Appointments. Section 8 creates the Commission on Judicial Performance. Section 9 creates the State Bar of California. What jurisdiction do state court judges have? Section 10 specifies that the Supreme Court, the courts of appeal, the superior courts, and their judges have original jurisdiction in certain specified proceedings. Section 11 provides that the Supreme Court has appellate jurisdiction when the judgment of death has been pronounced. And Section 12 deals with appellate court jurisdiction in the state. What are the requirements for being a judge in California? Section 15 makes a person eligible to be a judge of a court of record with at least 10 years experience immediately preceding selection. That person must have been a member of the state bar or have served as a judge of a court of record in this state. Do California judges face election? Section 16 specifies that judges of the Supreme Court are to be elected at large, and judges of courts of appeals must be elected in their districts at general elections that are held at the same time and places as the governor is elected. Section 16 also limits terms to 12 years and specifies how justices are selected. When are federal court judges typically selected? The U.S. Constitution states that federal judges are to be nominated by the President and confirmed by the Senate. How long can federal court judges serve? They hold office typically for life, though congressional impeachment proceedings, federal judges can be removed from office for certain misbehavior. How are state court judges typically selected? State court judges are selected in several different ways, such as election, appointment by the governor, and they have specified terms or effectively life terms, depending on the state. How are California judges selected? In California, trial court judges are elected generally, but the governor does have the power to appoint judges to fill vacancies. For appellate court justices, the governor appoints them and then they're confirmed by the Commission on Judicial Nominations. Which types of cases are typically handled by federal courts? The federal courts are assigned cases that deal with the, for example, constitutionality of a law, cases involving the laws and treaties of the United States, cases involving ambassadors and public ministers, disputes between two or more states, and cases involving admiralty law and bankruptcy law. Which types of cases are typically handled by state courts? They normally handle criminal cases, probate, contracts, torts, family matters. They also decide on cases involving their respective state constitutions, state statutes, and of course, state regulations.